what is disclosure in a criminal case? That's a common question that clients talk to us about. We're always talking about the disclosure. What exactly is it? So let's take a hypothetical. You've been charged with sexual assault. The police conduct an investigation. They're going to get the hospital records of the complainant. If she attended for a sexual assault evidence kit, that's part of disclosure. They're going to take a video statement from her. There may be other forensic testing. There may be fingerprints, maybe expert reports. There may be other narrative witnesses. So the police have a complete investigative file. You are entitled to receive every single aspect of that file. That's the disclosure. So whatever the police have gathered, as long as it's relevant, you're entitled. Now, sometimes there's disputes about things that might not be relevant, not disclosed, and that's up to your lawyer to fight out in court. But what happens then is when you're charged and you hire a lawyer, your lawyer will immediately write the Crown. Typically, most Crown's offices have a form that we apply for disclosure, and we also do a detailed letter. And they're required to give us everything relevant from their case. That's a case from the Supreme Court of Canada called Stinchcombe, an old case that requires the Crown to hand over the entire investigative file for the police as long as it's relevant for you to make full answer defense. And anything that could conceivably remotely be helpful to the defense has to be handed over. They can't hold back anything. There's rare exceptions to that. I won't get into all the details of that in this. That's more maybe perhaps a topic of another video. So that's Stinchcombe. So what happens in terms of timelines? Well, if it's a minor, non-complex criminal case, let's say it's an impaired driving, the Crown, let's see, you've got an upcoming court date, the first appearance 4 weeks from now, your lawyer's requested disclosure. Will the Crown have that to you, the initial disclosure before the first court date? Sometimes. They'll have it probably shortly after the first court date in most cases. Now, the initial disclosure package that we get, often it's not complete. Often we have to review that. A, B, C, D is missing, and we have to write the Crown for that, and the Crown will usually comply as long as they agree with us. If they don't agree with us, we may need to bring a disclosure application to argue in front of the judge that they're withholding disclosure that's relevant. The Crown might have a particular argument, legal argument, to make why it's not relevant, and we have to go in front of a judge to do that. On more complex cases, disclosure takes longer. An initial disclosure package on a serious charge, like a murder charge, might take months to provide. There's typically going to be a lot of missing disclosure, and sometimes these cases have 3,000 documents and videos and you name it. And it's up to your lawyer to carefully scrutinize that, go through that, figure out what's missing, and keep on the Crown and keep bothering. Disclosure is so important for you to make it full answer defense, because your lawyer and you needs to know every single aspect of the Crown's case in order to break it down and attack the credibility and reliability of witnesses. And that's the importance of disclosure. Before Stinchcombe, disclosure was really hit and miss in Canada, depending on the province and the particular office. Sometimes you might just get 10 sheets of paper on a very complex case. Stinchcombe came out years ago and said, we're entitled to full disclosure. We're in a democratic country. You need to know the case that you're going to meet. And what I typically do is once I get enough disclosure, I meet with the client, have them pour over it with me. I explain the defenses to them, explain their options, explain what's missing. At that point, I'm ready to at least take an initial statement from their client about their version of events. I don't want the client really getting their complete version of events until they fully understand every aspect of the Crown's case, what the complainant's saying, what the other witnesses are saying, because it's just, you don't want to be pinning down to a client a version of events where they go, there's that little piece of evidence, because we have to answer to all that evidence. So every case is different, but we always advise clients, look, don't necessarily expect disclosure by the first court appearance. It may be coming after that. That's not unusual. Sometimes it takes months to get the missing disclosure. We have time. We're in the Ontario Court of Justice Management Intake Court, remand court, and disclosure can take months on some occasions to get complete disclosure. And in complex cases, I've got a case I'm working on right now that there's thousands of documents. I have poured through that case multiple times, and each time I pour through that, there could be a little missing piece of disclosure. So I have had literally 20, 30, 40 letters to the Crown about little missing pieces of disclosure. We now have complete disclosure, and the trial is, take place about 4 months from now. So it's a very careful process. Your lawyer has to know what they're doing. They have to know what they're looking for. And for you as a client, that's so important to know the complete case that's being against you so that you can fully respond to every aspect. So that is what disclosure in Canada is. It can be a complex process, it can be a simple process, or somewhere between, depending on the complexity of the case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.